Welcome back to another deep dive. Today, we are stepping into a scenario that probably keeps a lot of business owners awake at night.
Oh, for sure.
Imagine you spent 20 years building a company. It's your life's work. You've nurtured it, grown it, and you're banking on it to fund your retirement. Then, suddenly, a partner or a vendor, they breach a critical contract.
And they pull the rug right out from under you.
Exactly. The business collapses, or maybe you're forced to sell it for, pennies on the dollar just to survive.
It's the ultimate business nightmare. You're not just losing a contract. I mean, you're essentially losing your identity and your financial future all in one go.
Right. So naturally, you sue. You go to court, and you have a very specific number in your head.
Yeah.
You want the full value of the business you lost, obviously.
Of course.
But you also want the money that business would have made you for the next 10, 20 years if the breach hadn't happened. To a layperson, that sounds completely fair. It sounds like justice.
You broke it, you pay for everything I lost. Simple as that. But that's exactly where you hit a massive legal wall. It's a concept that trips up juries, lawyers, even seasoned judges sometimes.
And that is what we are unpacking today. We're looking at a stack of sources that center on a landmark case from the 10th Circuit Protectors Insurance Service, Inc. v. United States Fidelity and Guarantee Company.
It's a fascinating area because it sits right at the intersection of, well, complex business valuation and really fundamental contract law.
The central tension we're exploring is between two big ideas. On one side, the law says it needs to make the plaintiff whole, put you back where you belong.
Right.
But on the other side, there's a strict prohibition against double recovery. So the question is, can you get paid for the value of the business and the future profits? Or is that asking for the same dollar bill twice?
Exactly. Can you sell the machine and still charge for the products it would have made? That's the valuation paradox.
To guide us through this, we need a rigorous roadmap. How are we going to break this down?
We need to be systematic because the math can get slippery. First, we're going to define the but-for objective of contract damages. What's the actual goal of the law?
Okay.
Second, we'll examine the two primary methods of business valuation. That's going concern value versus lost future profits. And third, we'll apply the double recovery rule to explain why these two methods are, well, usually mutually exclusive.
And what's the key doctrine we're really hunting for here?
We're examining the principle that a plaintiff cannot recover the market value of a business, which, effectively capitalizes future earnings, while simultaneously recovering those same future earnings as a separate line item.
Okay, let's unpack this before we get to the case. Let's start with the basics of the doctrine. So what is the fundamental objective of damages in a breach of contract action, and what limitation does the law place on that objective?
So the general rule is simple but profound. The objective is to place the injured party in the same position they would have been in but for the breach.
Okay, a perfect world scenario.
We want to simulate a world where the contract was performed perfectly. However, there's a hard limitation. The rule against double recovery. A double or, a duplicative recovery for a single injury is invalid. The plaintiff cannot be compensated twice for the same economic loss.
That sounds fair in principle. Don't get paid twice for one bruise. But how do courts actually spot a violation of that rule? It feels like it could be subjective.
It's not subjective if you follow the test. We look for three elements. First, you establish a single injury. Second, you identify overlapping damage calculations. And third, you adjust to ensure the compensation doesn't exceed being made whole.
So you can't end up better off.
You cannot end up better off than you would have been if the breach never happened.
We're going to test this rule using the Protectors Insurance case. But before we dive into those dense facts, I want to clarify this valuation paradox with a hypothetical. I'm calling this one the indestructible golden goose.
I love a good goose hypothetical. It usually clears things up immediately.
Okay, imagine a farmer has a magical goose. This goose lays one golden egg every single month, like clockwork. Then a neighbor creates some disturbance, negligently, let's say, that kills the goose. The farmer sues.
A classic tort or breach scenario. The farmer has lost his asset.
Right. Now, when he asks for damages, he says, I want the value of the goose, and I want the value of all the eggs it would have laid for the rest of its life.
And that is where the trap snaps shut. Let's analyze this carefully. What's the going concern value of the goose? It's the price of the live bird.
Okay.
But why does a buyer pay a high price for a magical goose? A buyer pays that price precisely because it will lay future eggs. The market price of the goose effectively equals the present value of all those future eggs.
So the value of the eggs is baked into the bird.
Exactly. The bird is just a container for the future eggs. So then you have the lost profits value. That's the value of the eggs themselves over time. Now, apply the double recovery rule. If the court awards the farmer the full market value of the live goose, which already prices in the eggs, and the cash value of all future eggs,
He's been paid for the eggs twice.
he has been paid for the eggs twice.
That really drives it home. Viscerally, you cannot sell the carcass for the price of a live bird and keep the eggs it would have laid. You have to choose the bird or the eggs, not both.
Precisely. If you get the value of the bird, you've been made whole because you can take that cash, go to the market, and buy another golden goose that lays new eggs. If you get the cash for the bird plus the eggs, well, you're now richer than you ever would have been.
With that image in mind, let's analyze Proctor's Insurance Service, Inc. v. United States Fidelity and Guarantee Company. This is a real-world application of the goose problem. So let's get into it. First, what are the legally dispositive facts?
Okay, let's look at the essential facts. The plaintiff was Proctor's Insurance Service, owned by a man named Earl Glazier, our real-life farmer Earl.
Oh.
The defendant was US F&G, a large insurer. Proctor's was an insurance agency that sold their policies.
And the trouble started with the contract between them.
Right. The breach occurred when US F&G violated the rehabilitation clause of their agency agreement. Essentially, they tried to terminate the agency without giving them a fair shot to fix profitability issues. This forced Proctor's into a distressed position.
So they had to sell.
They had to sell. Facing termination, Proctor's sold its assets to a third party, the Centennial Agency, for roughly $148,000 in cash.
Okay, so the goose was sold. But $148,000 sounds low for an insurance agency.
It was a fire sale price. And this is where the valuation testimony comes in. The plaintiff's expert, John Putnam, he testified that if the agency hadn't been sold under distress, if it had been sold as a healthy, normal business, it was worth $175,000.
Okay, and how did he get to that number?
He calculated this using capitalization of earnings.
Can we pause on that term? Capitalization of earnings. What does that actually mean in plain English?
It's exactly what we did with the goose. The expert looked at the future income stream the business was expected to generate. He did some math to bring that value into today's dollars and said, this is the price tag.
So he priced the business based on its future profits.
100%.
Okay, so we have a sale price of $148,000 and a theoretical fair price of $175,000. What did the jury do with this?
The jury made a fascinating and, well, a problematic decision. They awarded two distinct things. First, they gave him $35,000.
The difference.
Right, the difference between the fair value of $175 and what Proctor's actually got. But then they also awarded a second bucket, $809,650 for lost future profits.
Wow. $35,000 for the business value and almost $1 million for the profits.
Exactly. They gave him the difference in the bird's price, and then they gave him a massive check for all the eggs.
So what was the core legal issue that went up to the 10th Circuit?
The legal question was this. Did the district court make a mistake by instructing the jury that they could award both the diminution in the sale value of the business and lost future profits? Or did this constitute an impermissible double recovery under Colorado law?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements for us.
The court relied on a well-settled rule for business damages. When a business is lost because of wrongful acts, damages are measured by one of two alternative methods. The rule here really has three critical elements.
Okay.
Element 1 is the going concern value. This is method A. It's the difference between fair market value and the actual sale price. Element 2 is lost future profits. This is method B, calculating the present value of lost future earnings.
And the third?
Element 3 is the constraint. This is the mutually exclusive limitation. A plaintiff can recover method A or method B, but generally not both, especially if method A relies on future earning potential.
Thank you. Now, for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the going concern value?
Okay, let's do a mini IRS for element 1. The subrule here is that going concern value is the price a willing buyer pays a willing seller. But crucially, and this is the pivot point, this value necessarily takes into consideration the business's future profit earning potential.
Okay, how did that apply to the facts?
Well, the court looked straight at the expert witness, Putnam. He testified the business was worth $175,000, but he admitted explicitly that he got that number using capitalization of earnings.
He used the future income stream.
He used the future income stream to determine the price tag. So the court's conclusion on this element was that the $35,000 award, that difference, represented the full going concern loss.
Yeah.
That $175,000 number already had the future baked right into it.
Understood. That covers the value of the goose. Now, what about the second element, lost future profits, and how it interacts with the third element, the mutually exclusive constraint? This seems to be where the jury went off the rails.
This is where the court dissects the error. So let's mini IRAC elements 2 and 3 together. The sub-rule is that double recovery happens if the plaintiff gets the market value, which includes future potential, plus the future profits themselves.
Right.
Applying this, the jury awarded that $809,000 in lost profits, but the plaintiff had already cashed out. Protectors sold the business for $148,000. Then the jury gave them the $35,000 top-up to reach the full fair market value.
So he was already made whole.
By receiving that fair market value, the plaintiff received the present value of all those future earnings.
But didn't the plaintiff argue there was a distinction? I think I remember reading about an exception in a case called Atlas Building Products. Why didn't that apply here?
That's a great question, and the court had to address it. In Atlas, the business continued to operate. So if you keep the business, you might have lost profits for a period of time, and your asset might be worth less permanently. But here, the court emphasized the business was sold.
A critical distinction.
Huge. So the conclusion was inescapable. Because the business was sold as a going concern, the sale price plus the $35,000 correction made the plaintiff whole. Adding the $809,000 was essentially paying him for the eggs after he had already been paid full price for the goose.
And after analyzing all the elements, what was the court's final conclusion?
The holding was decisive. The 10th Circuit vacated the $809,650 lost profits award, just wiped it out entirely.
And the synthesis.
They affirmed the $35,000 diminution award. So the plaintiff keeps the proceeds of the sale, the $148,000, and gets the extra $35,000 from the defendant to reach fair market value. But he forfeits that separate lost profits award.
That is a tough break for the plaintiff, losing nearly $1 million on appeal. But when you look at the math, if they had allowed the lost profits, he would have the cash value of the business and the income stream. He'd be richer than if the breach never happened.
Exactly. It violates the but-for principle.
Now, this case provides a really clear warning for anyone looking at business damages. If you're a law student or a practitioner, you need a way to spot this issue before it goes to a jury.
Definitely. You need a systematic way to approach these facts so you don't get blinded by the big numbers.
So let's synthesize this. Based on protectors and the doctrine we've discussed, can you walk us through a diagnostic checklist for exam taking or case analysis on business damages?
Right. Think of this as your double recovery diagnostic. Step 1 is the status of the business. You have to ask, was the business sold or destroyed, or does it continue to operate?
Okay.
If it was sold or destroyed, like in protectors, you go immediately to step 2. If it's still operating, you have to pause and look for that Atlas exception. In that rare case, you might be able to claim both.
Okay, but assuming it's sold or destroyed, what's step 2?
Step 2 is the valuation method check. Look at the plaintiff's expert. Did they calculate fair market value or going concern value? And here's the crucial question to ask. Did that calculation rely on capitalization of earnings or future income streams? And the answer is almost always yes.
And if the answer is yes, that leads to the trap.
That leads directly to step 3, the double recovery trap. If the plaintiff is awarded fair market value from step 2, they cannot also claim lost future profits. The rule is strict. You select the higher of the two, or the one you can prove with certainty, but you never combine them. You can't stack them.
And finally,
Step 4 is the made whole test. This is your sanity check. Just verify that the award represents the position but for the breach. Do the math. If the math implies the plaintiff has the cash value of the business and the income from it at the same time, you have to strike the duplicate award.
that framework really clarifies why the court ruled the way it did. It wasn't about punishing the plaintiff. It was about mathematical fairness.
It's about economic reality. The law assumes a free market. In a free market, when you sell a business, you are selling the rights to those future profits. You transfer the risk and the reward to the buyer. You can't ask the defendant to pay you for rewards you already sold to somebody else.
This deep dive into protectors v. U.S. F&G really highlights how tricky damage calculations can be. It's not enough to just prove the other guy did something wrong. You have to prove what you lost, and you have to count it correctly.
And you have to remember that value is just a shorthand for future benefits. Once you understand that, the rule against double recovery stops looking like a technicality and starts looking like just plain common sense.
We are going to leave it there for this deep dive. A huge thank you to everyone listening. Hopefully, next time you see a lost profits claim attached to a business value claim, some alarm bells will start to ring.
And you'll remember the golden goose. Choose the bird or the eggs. You can't have both.
Thanks for listening. We'll catch you on the next deep dive.